It does scatter. It does scatter. Today will be the deadline. 10th of February will be the deadline for old Naira note to go back to where it came from. Yes. Now court don't say may a shifter. Thank you, Rufai and Dr. Bati, for the math wanna chook for this issue. Mokuna listen to waiting AGF. Malami use the math they talk for phone call where arise. Caller. I don't know how a whole court will be giving the federal government order. I don't really know. I don't get this test of government anymore. Everybody have their own rights, their own power. I don't understand waiting consign old Naira notes with Kaduna State. And they didn't even follow due process. They went to Supreme Court straight. All these things, that's what we supposed to ask ourselves. You go use no say these people they will just want to rig this election. The APCs are the one gingering these things. Watch them.
It will comply with the order as a demonstration of government's commitment to the rule of law. The AGF says his office has filed a preliminary objection challenging the jurisdiction of the court.
An interim order was granted by the Supreme Court, and that order was to lapse on Wednesday, which incidentally is equally a date fixed for the hearing of the motion on notice. So in line with that position in mind, we have taken steps to file an objection challenging the jurisdiction of the court to entertain the matter. Jurisdiction on the ground that when you talk of monetary policy, regardless of the character they take, central bank is an indispensable and necessary party for that matter. What we have at hand is a situation whereby the central bank is not joined as a party. And if the central bank as an institution is joined as a party, the position of the law is clear that the original jurisdiction of the Supreme Court cannot be properly invoked. So we have given consideration to diverse issues, inclusive of the issues of jurisdiction, and come Wednesday, we'll argue the case from that perspective, among others. I think what we are talking about is not whether the ruling is binding or is not binding. We are talking about what we intend to do. There is no doubt about the fact that the ruling of the Supreme Court, regardless of the prevailing circumstances, is binding. And then, within the context of the rule of law, you can equally take steps that are available to you within the context of the spirit and circumstances of the rule of law. And what we are doing, in essence, is compliance with the rule of law, both in terms of obedience to the ruling and in terms of challenging the ruling by way of putting across our own side of the story, putting across our case, challenging the jurisdiction. So the issue of obedience to the ruling of the Supreme Court is out of it. We are wholeheartedly in agreement that naturally we are bound by it and that we will comply accordingly. But within the context of compliance, challenging the ruling by way of filing an application or by way of challenging it and seeking for it to be set aside is a different thing. It is all about the rule of law. The rule of law provides that there has to be obedience to the judgment and orders of the Supreme Court will operate in obedience. The rule of law provides that when you are now not happy with a ruling, you can now file an application, among others, for setting aside, and in compliance with the right and privileges vested in us as a government, we are equally looking at it from the perspectives of challenging the order and seeking for it to be set aside. So it is all about the rule of law. Rule of law relating to obedience and compliance. Rule of law relating to filing an application seeking for the judgment or orders to be set aside. We are operating within the context of the rule of law anyway.
Okay, that's about your lot to break down.
Well, does the Attorney General of the Federation, does he have a choice in the matter? I don't think so. As the chief law officer of the Federation, he is obliged to defend the rule of law. So when the Attorney General of the Federation says he's going to respect the rule of law, then of course, there's no question about it. That's the way it has been. People will think that this is a big deal because previously, even the office of the Attorney General of the Federation had been accused of disregarding decisions of court. But in this particular case, the Supreme Court is the apex court. Its decision is final. And so where will you go beyond the Supreme Court? It's only the Supreme Court that can reverse itself in any matter whatsoever. So it's good to hear that the rule of law is what is motivating the Attorney General of the Federation. And that, in other cases, we also hope that the Office of the Attorney General of the Federation will take exactly the same position. Now, beyond all of this, he also alluded to the grounds on which they are going to back to the Supreme Court. The hearing is for February 15. And the key issue, the key questions that have been raised is, one, whether or not the Supreme Court has jurisdiction over the matter. And the argument that Ghazali and Magaji, both SAN, who are representing the Attorney General of the Federation, are putting up, is that by not joining the CBN as a necessary party in the matter, the jurisdiction of the CBN, of the Supreme Court, is limited in this particular instance. Now, there have been many arguments in this regard. I've seen people saying, look, the CBN, in exercising its functions, under the CBN Act of 2007, sought approval from the president, who has executive powers of the Federation under Section 5 of the Constitution. And to that extent, the powers of approval given to the president under Sections 4 sub 3 of the CBN Act, Section 6 of the CBN Act, Section 19 of the CBN Act, Section 20 subsection 3 of the CBN Act, will seem to indicate that the necessary party in the case is the president who is exercising executive powers of the Federation. And hence, that's why the Attorney General of the Federation is the sole respondent in the matter. But we will see how that question is resolved. The other question is that the learned Sikhs, they are arguing that the states did not show necessary course of action. In other words, they've not been able to demonstrate how they've been affected in this regard. It's also for the court to look into that. But their own lawyers, the plaintiff's lawyers, had argued before the Supreme Court that the policy execution was causing problems in their respective states. And so to that extent, are they suffering damage or not? Number three, the learned Sikhs are also arguing whether or not the matter should have been instituted first at the Federal High Court. Could it be that it is the Federal High Court that has exclusive jurisdiction over this particular matter within the purview of Section 251 of the Constitution? That's also another question for the court to determine. And then, of course, they are also asking whether within the purview of Section 17, 18, 23, whether the CBN, whether the Supreme Court can inquire into the CBN performing its statutory functions under the law. When they go to court on Wednesday, I think February 15 is Wednesday, they've already filed a notice of preliminary objection. So the court will look into it. The court can either reverse itself, or the court can give an order that the president of Nigeria should withdraw his approval. The court can do as it deems. But what is established is that nobody can just ignore the rule of court. As Femi Falana SAN argued in an opinion yesterday, quoting Nikitobi JSC as it then was, in AG Lagos versus AG Federation. If you don't respect the rule of court, that will amount to provocative contempt. Contemptuous of court, and the office of the Attorney General of the Federation cannot be seen to be contemptuous of the bench, or particularly of the Supreme Court, because that would translate into anarchy. So it's a good thing that they have filed their objection and they will go there, they will respect the rule of law. But what is the meaning of respecting the rule of law? Because the Attorney General was also quoted as saying that in any case the ruling expires on February 15. But on February 15, I hope the federal government, through the office of the Attorney General, gets its day in court.
First, I think because of this conundrum, there needs to be a position paper. Because when you check either to what the CBN put out, it was supposed to cease to be a legal tender on the 10th Then there was a grace period until the 17th to be able to put the notes in, to be able to foster, digital processing of excessive cash and things like that. And people have also been picking up these notes. So what is the position paper now? Because there was an hitherto position that I referred to yesterday by some of the lawyers in the CBN. It was out there, but the CBN can, allude to that or debunk that they were not joined in the suit. So we need to have a comprehensive position paper as regards this. Secondly, the different points of argument here will be about majorly the jurisdiction. And a lot of people have argued, like you said, Dr. Pati, that this should have originated from the Federal High Court. Because in a similar suit, to tell the federal government not to stop, to continue with the dates, not to halt the date, that was filed by 4 political parties. That was filed in the Federal High Court. And that suit was there before the Supreme Court ruling was gotten by the 3 governors. Also, as regards the course of action, there have been rebuttals by other governors. Governor Obaseki came out today and said that Governor El Rufai cannot speak for the generality of states in Nigeria, that for them, it doesn't affect those states. And also, in exploring the course of action, the question will be, what will be the hardship effect on the citizens of the state? What will be the knock-on effect? Because predominantly, if we want to extrapolate, the only state we've had crisis, I'm not sure any of these states have had any riot or crisis. It's just been in Ondo, Ogun, predominantly, and a couple of other states. But it is for the court to determine, the course of action. Also, I think this will also, bring about the conversation on the independence of the CBN. Because as regards this policy, yes, there's an independence of the CBN, but there was a caveat in the CBN Act that talks about the fact that you have to get a nod of the president to be able to do monetary policy. So the question is, was it partial independence or full independence? I mean, there's a lot that can be said on this case, but we'll take a short break now. And when we return, we'll have Ruth Sudiri to give us updates on global and Africa business activities. Stay with us.
These people have no shame. These people are so shameless. Just imagine a whole AGF. No shame. So it's in they talk. They are just bent in destroying this country. Please and please, it's time we vote for competency, credibility, and accountability. Let's vote for a Nigeria that we can trust. Please and please, share this video. Subscribe to my YouTube channel. And remember, Labour Party Sheila,